So as my colleagues just kindly introduced me, my name's Emma Christian. I'm a people consultant as part of the people projects team at Nathan Solicitors. So I work in HR typically, consulting with our clients on many HR matters, from anything from ad hoc on-site assistance all the way through to strategic support. Anyway, so today's session is, as Kane had advised, is on grievances and handling conflict in the workplace. So let's get started. Agenda. So we're going to cover off essentially an overview of grievances, how we would handle grievances, what we would do if a claim arises from failing to handle grievances correctly, or if a problem arises during handling the grievance. Bullying and harassment and how that impacts how we would address concerns that are raised, managing personal relationships within the business, preventing and dealing with bullying and harassment at work, and of course, whistleblowing. Screen. Great, thank you. So just as an overview of grievances, a grievance can be anything really that an employee raises, whether it be informal or formal, where they are not happy, and that can be for any reason essentially. But the most common examples that we tend to come across are things like working conditions, and that might be that the employee is not happy with their terms and conditions. It may be that they have a dispute over their pay, for example. Bullying, harassment of colleagues. So a lot of employees will throw this term in as bullying or harassment by their colleagues when they have fallen out with somebody. But quite often where they have expressed some treatment, and that could be simply isolation, segregation from colleagues, or it could be more direct in terms of like name calling, etc. And we do need to handle that extremely carefully, because we need to make sure that we're not going to leave ourselves open to any potential claims. Health and safety issues. Again, these could be serious claims where somebody is at risk of their health, or it could be something fairly minor, but nevertheless, if they do raise a health and safety claim, it is likely to be protected, and therefore we do need to be really mindful when someone comes to you. We need to make sure we are investigating that matter thoroughly. A discrimination, and that is in relation to any protected characteristics, so whether that be race, religion, sex, gender, etc. We do need to ensure that we are investigating those matters seriously and taking on board any concerns and addressing them as swiftly as possible. So, I mean, how do you actually identify what a grievance is? So a grievance doesn't have to actually state it's a grievance. So it can be a verbal, I'm not happy. It can be just a note to say, I want to raise a complaint. But you will sometimes get that letter coming in, I wish to make a formal grievance. But it doesn't matter, you know, if an employee raises a grievance, regardless of the capacity or how they've worded it, it has to be investigated thoroughly.
And it's also important to notice here that grievances don't necessarily need to say that they are a grievance. You will get letters more often than not that say grievance at the top of it, or they'll start with, this is a grievance, please treat it like a grievance in accordance with the company's grievance procedure. That's always very nice. That's clear that it is a grievance, and you know then how to deal with it. But does it have to say that it's a grievance? No, it doesn't. It just needs to be some kind of complaint, basically, from the employee that says that we're not doing something that we should do procedurally or otherwise. Maybe there's some bullying going on that's referenced in the letter. We would still have to deal with it as a grievance, even if it doesn't say, please treat this as a grievance. This case of Commotion and Rutty was essentially a flexible working application made by Mrs. Rutty because she had to look after her grandchild. She has to work a fewer days a week instead of the full time 5 days a week that she was working at that point. And the request was refused because the employer said that they needed somebody to work in that role full time 5 days a week. She appealed, and the tribunal found that the appeal itself against that decision, because it contained comments about the fact that Mrs. Rutty felt the procedure was flawed, the way they dealt with the flexible working request was flawed, that in itself was a grievance. So that was enough to be able to say it's a grievance and you should deal with it as a grievance under the grievance procedure. The fact that they failed to do that when it got as far as an employment tribunal resulted in an increase in compensation, essentially because of failure to follow the ACAS code of practice on dealing with grievances. So how should grievances be handled then if we do get either a clear grievance from an employee or a complaint that looks a bit like a grievance and we think that we should deal with it as such? I think the starting point for anybody here, any companies where any employees making a concern, is to try to deal with it informally. We don't have to go straight to the full grievance procedure where we're inviting people in to investigation meetings and to formal grievance meetings where they can be accompanied. There isn't necessarily a need to do that. If we can deal with it informally, we can have a chat with the person who's raised the grievance, see what they want out of it, and get to where they want to be without following this kind of formal process. Then that's always preferable. It keeps employee relations in check. It makes sure people kind of leave this process amicably. If we start to deal with it formally, then it can get a bit fraught. If there's an investigation going on, employees may get reluctant to attend or to take part, and then we have to put a grievance outcome in writing to the employee. It gets a bit tricky when it comes to maintaining employment relationships with staff. So it's better to deal with these things informally where it's all possible. If that's not possible, and often it isn't, a word with the employee who raises the grievance in the first place might be enough a lot of the time to just get what they want out of it, reassure them that there's nothing wrong, or maybe correct a misunderstanding or something along those lines. Maybe there could be a word that says that we'll have a chat with this employee that they're complaining about and they're happy with that. That's fine. That will be the end of the process. If not, and they do want to deal with it formally, then we have to go through the formal procedure. And this is something you can just ask employees. If they've raised a grievance, we can say to them, do you want to deal with this informally or go through the formal grievance procedure? They might choose either way. If they choose the formal route, then we kind of have to go through the formal process in accordance with the ACAS code, which essentially says that the employee needs to raise a grievance in writing. It says it should be in writing, but really, if they make a verbal complaint, you would still need to treat it as a grievance. The employer should then investigate the complaint, hold a grievance meeting. Employees can be accompanied to grievance meetings just like they can to disciplinary and disciplinary appeal meetings by a trade union rep or a colleague. The same rules apply if a trade union rep or a colleague can't attend with them. You need to rearrange the meetings to take place within the next 5 days. That's generally how it would work. And once the grievance meeting does take place, a decision needs to be communicated in writing. The grievance meeting, unlike with disciplinaries where you'll often speak to the witnesses first before having a meeting with the employee here is the one who's making the complaint, so I kind of need them to put some more meat on the bones first before we can do anything about it. So we'd have that meeting with the employee first normally, before carrying out further investigation, because after we've spoken to them, we'll have a bit more of an understanding as to how we will investigate and who we'll speak to. Depending on the nature of the complaint as well, you may have a meeting with the employee at the end of that process, but it's not strictly necessary. The outcome can then just be confirmed in writing.
Okay, so I mean, just going into this a little bit more deeply then and handling grievances informally. So as Anthony quite rightly said, ideally, where possible, we should try and address concerns on an informal basis rather than allowing it to escalate and requiring a full formal procedure. It is much better for employee relations, and if we can nip something in the bud before it becomes a big issue, then hopefully we can resolve it without it blowing up. So I mean, in terms of actually addressing them, the main point really is trying to get that agreement. We need either agreement of change or action that's being requested. So where they've raised a complaint about a working environment, for example, maybe because the temperature it is not suitable for them and it's causing concerns around the health. We need to investigate that and see if we can address it accordingly. It might be simple that we can just adjust the temperature in the immediate area without it disturbing other colleagues. It may be that we look at moving that employee, if they're happy to a more comfortable area of the office, and that can be addressed quite quickly and simply without the need for it to be a formal grievance procedure. Equally, it could be in relation to a complaint about another colleague. They're not happy about something that the colleague is doing, it's irritating them. Again, it might be that we can just have a quick chat with that other person and address those concerns accordingly. And where it might be that two individuals aren't seeing eye to eye, as it often is the case, and we have two employees that have got very different personalities and they just clash. Having a facilitated conversation or mediation session with those individuals may be enough to address the underlying issues, to draw a line in the sand and be able to move on a more stable basis without them irritating each other, without them causing more upset to one another, and then it becoming a big issue where they're basically refusing to work with one another. In circumstances like that, ideally, if you're going to be doing facilitated conversations or mediation, a trained mediator would be ideal, as they are fully trained in how to facilitate that conversation correctly. However, you can do that without training with some guidance. So it would be worth contacting, if you are a HR3 client, one of the HR3 consultants to discuss how you would do that. If obviously it does need to go into a more formal process, then it would have to be then someone impartial. Essentially, we can provide an outcome in writing following an informal grievance or complaint, but we still need to make it clear to them that they would have the right to raise a formal grievance if they are not happy.
So moving on then to having a look at the formal procedure itself, should the informal process not result in the outcome that we want or that the employee wants, who's raised a complaint, or if the employee wants to go straight into the formal process, which they are entitled to do, they can ask us to do that, and then we'd be obliged to do it, really. The informal resolution hasn't worked, so what happens next? We invite them into a grievance meeting, basically. We have a look at the letter that they've given to us, raising the grievance, and invite them into a grievance meeting. If they have raised the grievance verbally, I would suggest asking them to put it in writing, because if they put it in writing, you'll have more details to go off, you'll have more information to go off when actually speaking to them about it, and when carrying out the investigation. It's better to have that in writing rather than just taking it verbally anyway, so that you have a record of the grievance that was raised. By them thinking about it and putting it down in writing, they will probably be able to give you more information that way. So when we have a grievance meeting, we'll invite the employee in and we'll have a chat with them about the grievance and what their concerns are. This is their opportunity to put a bit more, as I said earlier, meat on the bones of this situation. Tell us what's gone on, tell us what their issue is and what we can do to resolve it. That's quite an important part. We need to know what it is that they want out of this, so that if possible we can try to aim for that. If we don't know what they want, it's difficult for us to then come to an outcome that everybody will be happy with. So investigations should happen after the grievance meeting has taken place. We'd basically speak to any witnesses that are referred to in the grievance or who might have seen something. If there's a complaint about bullying, who witnessed the conversation? Has anybody else had this kind of situation with the same employee? Is there a common theme here? Have a think about it. And then before we come up with an outcome, we'll need to consider any of the information that we get from these witnesses alongside the grievance that has been raised and essentially compare them, and do they corroborate each other? Does the grievance now stand some water, and do we have to take some action in relation to it? This is something we need to consider when we do give an outcome. The outcome, because it's a grievance, needs to go along the lines of the grievance is either upheld or it's rejected. If there isn't enough evidence to support it, then we can reject it. We would have to reject each part of it because each grievance point that's raised as a complaint is kind of a separate issue that needs to be dealt with. So if we can uphold some parts but reject others, that's fine as well. We would also need to consider whether or not we need to take any disciplinary action against the employees who are to blame here. If there is a bullying culture or something along those lines, we'd have to deal with those employees outside of this process completely separately. We don't have to tell the employee here what we're going to do, but we do need to deal with it ourselves separately, and we can tell them that we'll be dealing with certain issues in accordance with our processes should we need to do that. The employee still has the right to appeal, just like they would with the disciplinary. If they're not happy with the outcome of the grievance, they can appeal it to somebody independent. That after the appeal is the end of the process. There's nothing much that they can do once the appeal is dealt with and once the outcome is confirmed. That's the end of the road as far as the grievance appeal goes, the grievance process internally goes. And if they want to take any further action in relation to that, then they need to take it to an employment tribunal if they feel they have a claim there. So in terms of the grievance, once the grievance is dealt with, is it well-founded or not? This is just in relation to the outcome itself. So what action are we going to take? As I mentioned earlier, we need to give an outcome in relation to each point raised in the grievance. So a grievance might contain 5 or 6 allegations about certain people or certain comments that were made on certain dates, certain behaviours they're not happy with. So if three or four of those are well-founded, but 2 aren't, 2 can be rejected. But what are we going to do about the 3 or 4 that have been found to have some water here? What do we need to do about them? If it's a misconduct issue in relation to those other employees, if their behaviour is not something that's acceptable to us in the workplace, then we need to deal with them in accordance with the disciplinary process, as would with anybody else. We tell the employee as part of the grievance outcome that we will just be dealing with that, not necessarily that we'll be disciplining them or that we'll be giving them a warning or who will be disciplining. They don't need that information. That's confidential. That's something to deal with the employees themselves. But we can tell them that we'll deal with these issues in accordance with our internal policies. So they won't find out the outcome of any disciplinary process, but that will happen in the background. If the grievance is not upheld, we need to be explaining the reasons why. So we can't just say there isn't enough evidence to support this ground of your grievance, it's rejected. There needs to be a bit more explanation than that. Yes, that might be true, there isn't enough evidence, but why? What kind of evidence are we looking for here that would support it, and why don't we have that? If the witnesses that they've referred to simply haven't been able to corroborate the points that have been made here, so they didn't witness any comments being made, they didn't witness any conduct that would be unreasonable to any member of staff, then there's nothing to suggest it took place. It's one word against the other. And there seems to be no reason why it would uphold it in that case, because there's no evidence to support it. Finally, we'd give them a right to appeal. We usually give them a right to appeal within 5 working days or 7 regular days, including weekends. If they don't do it within that time frame, yes, you have the choice to hear it while it's late, but you don't necessarily have to because they haven't followed the process properly, and we have given them the right to appeal. So no, you don't have to go down that route if they are late. But if they do appeal, we'd have to deal with it as an appeal against the grievance, and hand it over to an entirely independent person to sort that out on behalf of the company. The appeal is generally going to be a review of the decision and a review of the evidence that was considered at the time, not necessarily a new investigation, but is there anything new that the employee can bring to the table that will cause the decision to be any different? Employees a lot of the time will just be unhappy about the outcome because it's not what they wanted, but they don't necessarily have any more information that would cause us to have any concern with the outcome. They're just not happy. And just because they're not happy doesn't mean there'll be any change in the decision. And we just need to bear that in mind when we are dealing with an appeal like this. So why is it important to handle a grievance properly? The main risk is that an employment tribunal claim will come following swiftly after. When there is a grievance, it's often about either the failure of the employer to follow some sort of internal process, or bullying or harassment or something along those lines. If we don't follow our grievance policy properly, then any claim that they bring, they can ask for an uplift on any compensation of 25% for our failure to follow the ACAS code of practice. Now, if you have a grievance policy in your handbook, then that will basically copy the ACAS code of practice. Everything that the ACAS recommends will be in there, and provided you follow that policy, then you'll be following the ACAS code. So there shouldn't be any risk there of a failure to do it, so no increase in the compensation at the end of it. But the claim itself, if we follow the process properly and we come to an outcome based on the evidence that we have, if we reject the grievance and we have good reason to do that, there shouldn't really be a problem. If we don't follow the process properly and we have failed in that regard, they may see it as a breach of trust and confidence, They may think that we're not dealing with their concerns properly, which could lead them to resign and claim constructive dismissal. It could also lead them to claim discrimination if they've raised a point about discrimination, which they don't feel like we've dealt with properly, and they feel they have no other choice but to take it further. If we're able to investigate fully these allegations of discrimination, and we just can't find any evidence, we've spoken to all the relevant witnesses, and our response to reject these is as solid as we can make it, it's less likely that they would have a leg to stand on should it go to a tribunal. But until we've carried out that full investigation, having followed the full process, we don't necessarily know that that's the case. So we run the risk of them being able to go forward with a discrimination claim when otherwise we could have put a lid on it at the grievance stage and dealt with it fully at that point. So it is important to deal with grievances like this properly, because we don't want people to be bringing tribunal claims, which could last another 18 to 24 months at the minute, given how long it's taking for claims to get through an employment tribunal. And it would also cost an awful lot more money than it would have cost just to deal with the grievance properly in the first place by simply following your own processes.
So, potential headaches. Handling a grievance during a disciplinary procedure, it's never easy when that happens, and a lot of employees will do it just by way of trying to delay a process. We also need to consider impact on other employees when a grievance is raised, and in relation to when somebody's trying to suggest that there's been bullying happening, that can be quite upsetting for other employees if they're being asked to be called as witnesses. It can affect the morale of the department. So I think it's really important that we ascertain who needs to know about the grievance. We need to be mindful of who we're actually asking to be witnesses, and we're not just doing a blanket go around the department asking their opinion on an employee, whether they think they potentially would be bullying somebody. We need to have reason to speak to that individual. In terms of resignations as well, now when you do have a resignation and an employee either alludes to raising a complaint or actually openly raises a complaint, it's really important that we don't ignore that. There is a risk of constructive dismissal here, as the employee may suggest that the only reason they're resigning is because they can no longer work in that business. It's a claim that they can only bring once they have 2 years service. However, if it's connected to any protected characteristic or any other protected disclosure, they can bring that claim from day one of employment. Confidentiality in sensitive cases, again, so that goes back to my comment about only speaking to people who need to be spoken to, not allowing everybody to be involved in a grievance. And then serial offenders. So we do occasionally have this. Somebody who keeps raising complaints one after the other. I think it's important to understand, are the complaints genuine? Is it that they're just not understanding maybe the responses that are being given by the organisation? And is the relationship becoming damaged between the employee and the business because of the number of grievances that are being raised? So that in itself does need investigating, and there are other ways that we can handle serial complainers, and it may well be that actually the right thing to do is to look at addressing all of those concerns, and then potentially, if they're unfounded, it could be seen as a disciplinary matter in its own right. But again, it's something that you would be recommended to take advice on if that does happen. So one of the biggest reasons that you'll get a complaint is because an employee believes that they are being bullied. Quite often it's my manager is bullying me because my manager needs to take me through a disciplinary procedure and I'm not happy about that, and therefore I feel like I'm being treated differently. However, once we've established that isn't the case, there are other reasons why someone may feel bullied. So we have a number of behaviours that are essentially unwanted, and they can be direct, such as aggressive behaviour towards people, or it could be that, as I said earlier, they're just merely trying to segregate them from the rest of the team. So there are some examples here. So threatening, aggressive, intimidating behaviour, abusive, insulting or offensive, cruel or vindictive, humiliating, degrading or demeaning. And all of this affects the victim's confidence. It's very negative on the individual, especially if it is targeted as well. And essentially, one thing we do need to be mindful of is if it's like the manager that's actually doing it to a subordinate. So we do need to be really on top of investigating such claims. Essentially, if it is founded, it could be deemed as gross misconduct. So we need to be quick with investigating it. And this is the kind of complaint that could lead to constructive dismissal, where an employee loses confidence in the employer's ability in terms of investigating it. So the other arm of bullying is harassment, and a lot of employees will use this term because they don't fully understand it, but harassment has to be connected to a protected characteristic. So it has to be that the employee is essentially receiving unwanted conduct relating to a protected characteristic, and which has the purpose or effect of violating that person's dignity or creating an intimidating, hostile, degrading or offensive environment for that person. Essentially, an employer can be held vicariously liable for any employee's behaviour. So it's really important that communication, training around equality and diversity is provided to all employees. And again, that we are investigating that swiftly and taking any action accordingly. Unfortunately, we can't stop a claim coming through on the vicarious liability, but a tribunal will look at what policies and procedures you have in place, what training you've given to your employees, and what action you've taken subsequently to deal with that. And that will go some way to defending a claim of that nature. So just some examples of harassment: physical gestures, graffiti, jokes, pranks, facial expressions. All those, they don't have to necessarily be verbally delivered to the individual. It can be all done behind the back. And it's also important to know, in terms of the protected characteristic, that the person doesn't actually have to carry a protected characteristic. But if they have a perception that they could be, and there was a case that was in relation to that, where a gentleman brought a claim of harassment on the basis he was being picked on for being gay, essentially, and he wasn't actually gay, but because the employees felt that he carried certain characteristics, they felt it was okay to be demeaning and offensive, essentially, about his personality. So yes, he brought a claim successfully against their employer on that basis. So how do we manage personal relationships in the workplace? So essentially, we need to ensure that communication is really crucial. In terms of the equality and diversity policies, we need to ensure that is all in place and that relevant training is delivered to all of your employees. And that carries in terms of your general relationships that you have in the workplace. However, personal relationships go one step further, and unless you have a formal policy on actual relationships in the workplace, it's important that individuals know that a personal relationship should remain that personal. It should be kept outside of the workplace. It should be noted that, if any poor behaviour is as a result of, say, a breakdown in personal relationship, it would be handled as a conduct matter and addressed accordingly. But it's also recommended that if you do become aware of a relationship, to speak to those individuals and just remind them of their obligations in regards to their behaviour, around other people and between themselves. Where concerns do arise, I dealt with a case a couple of years ago where a male and a female started chatting on social media, and they weren't aware that they actually worked for the same organisation. It was a very large organisation with multiple sites, and they got quite friendly. And as sometimes happens, the male decided to send some pictures of himself to the female. She wasn't impressed and she asked him not to do that again. However, he failed to follow that instruction and sent further pictures. At this point, they were now aware that they both worked for the same organisation. She asked him not to make any further contact. The female then ended up having a conversation with another friend who suggests that she raises a grievance with the company. And the following week, she did just that. The concern here is that the company, unknowingly, would potentially have a claim for vicarious liability. Now, in this situation, it's probably quite weak in that, the employees work in completely different sites. And as long as they had a conversation with their male employee in terms of that communication and addressed it accordingly, it is something that has happened outside of the workplace. But it is important to note that these kind of situations do occur, and the employer should be prepared to be able to address them. Obviously, it can become quite complex, these kind of issues, and therefore it would be recommended that you do seek legal advice on how to address them accordingly.
So when it comes to dealing with issues, then different companies will have different approaches to this. Their grievance processes, generally speaking, will be the same roughly, but their internal workings may differ from each other. So different companies will deal with this in different ways. But how might issues of bullying, harassment, and discrimination be raised? They can be raised in all sorts of different ways. A colleague may put it in writing that say that they're raising a grievance about bullying, harassment, and discrimination. That would be nice. If they then went into a lot of detail about what the claim is for, why the allegation is being made, and that kind of thing. However, that's kind of the tip of the iceberg. That's very rare. What you normally get is comments that are made from one employee to another about a certain other employee making comments to them that they were offended by. You might see posts on Facebook or LinkedIn or comments on a WhatsApp messaging page or something along those lines that another employee has raised with you and said, look at this employee has just put on here. And that's where you get the allegations of bullying and harassment and discrimination from. They might not come to you straight away. So the question is, how do you go and deal with that? I think initially we'd have to be speaking to the employee to try and get them to explain a little bit more about this issue. Is it a concern and is it something that they want us to deal with? And if it's inside of work, that's kind of our responsibility to do that. So we'll need to make sure that we are speaking to them. Companies will have to just ensure that they know who's responsible for dealing with these issues. If there is a grievance process, then generally speaking, there'll be a HR department in the background somewhere or someone who deals with HR issues. And HR would normally start the process rolling with this. Line managers will often get involved to deal with grievances themselves. I think in the first instance, it's better for line managers to deal with grievances because they're kind of the first point of contact with the employee. Provided they're not the ones who are being accused of bullying and harassment and discrimination, then that should be fine, which is why employers should make sure that their line managers are trained sufficiently to deal with these kinds of issues with staff. When there are allegations of bullying and harassment, they can get a bit personal. So line managers have to have those interpersonal skills where they can deal with the situation, even though they might get quite difficult and complicated. HR should generally be there in the background to offer support and advice through the process. So that's generally the way that I would suggest dealing with it. Have a line manager deal with the grievance and HR to advise the line manager on the process. If there isn't a line manager trained enough to deal with this kind of thing, then yes, HR can deal with grievances as well. And they quite often do, to be honest. Should the approach be informal or formal? We did touch on this briefly earlier, but both essentially is the answer to this question. Informal first, and if that resolves it, great. We can just have a chat with the employee and then just take some action in the background and get it sorted out that way. That might be easier, quicker, and more amicable for everybody involved, rather than taking them down the formal route. However, an employee may have gone past the point where they're happy with an informal process and they want essentially justice to be done and they want some kind of formal outcome from this. So they'll want you to go down the formal procedure. We ask the employee at the start of this whether they're happy to deal with it informally or formally. Now, we may take the decision out of their hands sometimes if the allegations are quite serious and we feel like it's not suitable to deal with them informally. Allegations of discrimination where quite serious conversations have been had or quite serious comments have been made, and it's quite clearly something we don't want to be happening, we may decide to take that formal route rather than informal, because we need to identify if this is happening in the business, and if it is, we then need to deal with it. But more often than not, an employee will kind of have the choice about whether they want to deal with this formally or not. If they'd rather deal with it informally, great. But if they tell you from the start they don't want to deal with it informally and the formal process is what they're looking for here, then that's the way that we need to go about it. Otherwise, they're unlikely to be satisfied with any kind of outcome. So how do we handle a complaint? Any complaint from an employee can be treated as a grievance, whether it's on Facebook or a comment to a colleague or anything along those lines. Any kind of complaint to do with work should be dealt with as a grievance. Make sure you investigate it fully. Once we've spoken to the employee during the grievance meeting, we can then go off and investigate by speaking to any witnesses that are referred to as part of the grievance. Anybody who's accused of making any comments and anybody who witnessed any comments should be spoken to get their point of view here, and can they support the grievances that are being raised. Then respond to the person who's raised the complaint. That will be the grievance outcome, where we give them an idea about what's upheld, what isn't, and why. Why is very important here. Make sure that we do tell them why, because otherwise they may not understand where we're coming from, and they may not think we've dealt with the process properly. Equally, we need to determine if any disciplinary action should follow. So if there have been allegations of bullying and harassment, we obviously don't want that to be happening. And if we find that there is some evidence to suggest that this may have happened, let's say because another witness has overheard what's been going on, and that a potentially racist comment or a sexist comment has been made by, let's say, a line manager to a colleague in their team, we don't want that to be happening. So we need to investigate further. And if that allegation has been made, we can take disciplinary action against the employees concerned if we need to. And that should be what we do. If we don't deal with it properly, then we know that that's happening in the background and that we haven't done anything about it. So the next time it should happen, it could cause even more problems. So it's better to deal with these things as and when they come up, rather than letting them linger and potentially having other employees raise concerns as their own because it hasn't been dealt with the first time. So if we don't deal with grievances properly, ultimately it could lead to employees being claimed in the employment tribunal. And this is what we want to avoid more than most other things. We want to avoid a tribunal claim. And if we don't deal with these issues, then this is ultimately where it's going to go. So there are a couple of cases here just in relation to discrimination and victimisation. So, I mean, I'm not going to kind of quote what's exactly happened in here, but they are just there for informational purposes. But in the first one from Royal Bank of Scotland, this is where an employer failed to properly investigate or deal with the grievance, where it was alleged that somebody was being discriminated against. That in itself isn't a further act of discrimination, and it depends why the failure took place. So an employee might come to you saying that they've been discriminated against because my line manager called me a certain name that I found offensive, and then we don't deal with the grievance properly in accordance with our grievance process. They then bring an employment tribunal claim saying this first allegation about the comment being made was discriminatory, but then the company's failure to follow the grievance process was also an act of discrimination. That's not necessarily always the case. It will depend on why it happened. As with discrimination, it's very subjective, and it will depend on what was going through the employer's mind at the time that they made this decision to not go through the grievance process. If it was nothing to do with the fact that this person had made, let's say, a complaint about discrimination, or that they were being discriminated against themselves, it was simply because they didn't have enough management in the building at that particular time due to holidays, and they didn't go through the process because of that lack of personnel, then that's not going to be discriminatory. But if the reason was because, well, we didn't really want to deal with it because it was discrimination, then that in itself could be discriminatory. If they raise a complaint about discrimination and we don't deal with it properly because we don't want to, because they've raised a complaint about discrimination, it's a vicious circle, but it could be a discriminatory act by an employer doing that. But it doesn't necessarily always mean that that's the case. In the second case of Hargreaves and Wright, the tribunal here found that the decision to dismiss somebody who had submitted a grievance was unfair, the dismissal itself was unfair, and it amounted to victimisation. So when we're looking at victimisation, again, this is like harassment, and a lot of employees use the word victimisation when they don't fully understand it. But victimisation is one of those things where you have to have a protected characteristic in the background, or you have to have some kind of protected act that has been carried out. So if somebody's raised a grievance about discrimination, that's a protected act. Or if someone supported somebody's grievance about discrimination, that's a protected act as well. And if we then dismiss somebody because they've raised a grievance or because they've supported someone else's grievance, then that's victimisation, because we've treated them unfairly because of them carrying out that protected act. That's generally where victimisation comes from. It doesn't apply just because an employee feels like they're the only person who's being singled out for doing a certain thing, when there's nothing to support that and there's no particular reason to support that. It doesn't work like that. It only applies where this protected act has been carried out in the first place. So in this case, the employer only raised issues with the employee's conduct and performance after they received her grievance, which is obviously bad timing. And if there were issues with performance and conduct beforehand, I would have hoped that they would have been raised before the grievance happened rather than after it, because even if these are genuine concerns that they have about performance and conduct, raising them just after somebody's raised a grievance isn't recommended because of the implication that it might have, and it suggests that it's just because they've raised a grievance. Even if that's not true, an employee will see it that way. And they failed to either investigate the grievance properly or to invite her to disciplinary hearing in respect of the alleged performance and conduct issues. So this was a failure to follow processes in relation to both grievances and disciplinary issues, which isn't ideal. And it looks, because of the timing here, I think more than anything else, it looks like this has happened because of the grievance that was raised. So all I would say here is, if you do have a grievance that's been raised, don't then decide after that point to raise concerns about conduct and performance. If there's genuinely a reason why they've only been raised then rather than beforehand, then fine, you might have only found out about them recently or since the grievance has been raised, and that's okay. But if you have issues with conduct going back for a few weeks or a few months, and then we decide to only take action about it once the grievance has been raised, that causes questions to be asked and is likely for an employee to go and bring a claim about it, because the timing is bad and it looks like something's been done because they've raised the grievance. So we want to avoid that. Again, this does only apply really where they raise complaints about discrimination in their grievance. If there isn't a complaint about discrimination, then there isn't any victimisation. So just bear that in mind. If they do raise a grievance about harassment or victimisation or discrimination, then we need to deal with it a bit more carefully than we would otherwise. Some more examples here. So the way in which an employee carries out his investigation into a grievance alleging discrimination or harassment could lead in itself to a discrimination claim. This kind of goes without saying. If somebody raises a claim about a grievance about discrimination and we don't deal with it properly, then that is going to cause some issues for the employee that is raised against. In this Martin and Parkham, just as a couple of examples, Mr. Martin, the claimant, was openly gay at work, and he complained about offensive and homophobic graffiti with his name written next to it on the wall of the men's toilets in his workplace. After an investigation, his name was removed from the wall, but the offensive drawing remained. Mr. Martin's name was subsequently written on the wall again next to the graffiti. The company put up a sign in the toilets warning against graffiti, but did not refer to homophobia. The company also told Mr. Martin that there was little they could do about it, and they couldn't really discover who was responsible. The tribunal wasn't happy with the way that they dealt with this and wasn't happy with their level of investigation. They made several comments when it got to a hearing about the inadequate way that it dealt with homophobia in the workplace, which obviously they could have dealt with a lot better in this kind of situation. The tribunal found the company would have dealt with his grievance more forcefully if it had not related to homophobia and it related to basically anything else, and that there was an inbuilt prejudice to the employer, even if the company didn't recognize this itself. So just because a grievance has been raised about a certain area of discrimination that we might not necessarily want to deal with, doesn't mean that we need to deal with it in any less of a stringent way than we would anything else. If there's an allegation about discrimination like this, I would have expected the company here to do an awful lot more to make sure that it doesn't happen again. Potentially speaking to the claimant and asking him what outcome he wants from this and what could we do to resolve it. But the way that they dealt with this, obviously the tribunal found that it was discrimination in itself by not following the process properly or fairly enough. In the second case, this shows the importance of an employer being able to demonstrate that it has adequately considered allegations of homophobia. So the claimant in this one was a chef, and he was dismissed for gross misconduct for uncontrolled, aggressive, and violent behaviour towards a colleague, apparently. The colleague had touched Mr. Yahiyahu. I'm going to go with it. Now, that pronunciation sounds about right to me, so I'll stick with it. Lightly on the side and asked if everything was okay. Claimant alleged that this incident was one of several acts of sexual orientation discrimination, including harassment and acts of less favourable treatment, and that his dismissal amounted to an act of sexual orientation discrimination in itself. When this went to a tribunal, the tribunal decided that the dismissal was unfavourable treatment on the grounds of his sexual orientation because his complaints of sexual harassment hadn't been investigated properly before he brought the claim, or at all. His complaints had either been ignored or trivialized, basically. So the tribunal was quite easy to find that there was no proper investigation and no attempt to deal with the grievance thoroughly at all. There was an appeal, and the appeal tribunal upheld the approach taken by the tribunal here. So the company can't get away with dealing with grievances poorly, generally speaking, and especially where there is discrimination or harassment that's being suggested here, as there was in this case and in the previous one. They're not going to get away with dealing with grievances in any less of a stringent way than they would with anything else. They need to follow their grievance process thoroughly and properly, investigate these things properly, and if they did that, they would probably have been able to avoid these claims being brought in the first place. And if there was a dismissal in the second instance here, then it could have been held to be about something else entirely. It might have been about his conduct or performance and wouldn't have been linked to any kind of discrimination just because he'd raised the grievance, if we dealt with the grievance properly, investigated it properly, and came to a proper outcome in the first place. Further, in relation to discrimination and victimisation, this is an approach that tribunals have tended to take in relation to these. So action or lack of action of an employer following an employee's grievance regarding any discrimination will also be relevant in its defence of a subsequent claim. So in this case, in relation to Smith, these kind of claims from the employment tribunal actually come up quite often. Employees succeed and don't succeed depending on how strong the case is. But in this one, a tribunal held that an employer could not argue it was vicariously liable for the actions of its employee in sexually harassing a colleague. So, as Emma mentioned earlier, in discrimination and victimisation cases, employers are essentially responsible for their own staff. And if they've committed harassment or victimisation by saying certain comments to a colleague, then the company can be liable for that. And an employee doesn't have to sue the colleague that made the comments. They can bring a claim against the company themselves, and they would usually do that. It's very rare that you see employees bringing claims against other employees. It makes more sense for them to go after the company because the company has more of an ability to pay, basically, than the employee would. So employers can, if they want to, argue the statutory defence in relation to discrimination claims. So this defence basically goes along the lines of, we've had a discrimination claim against us, but our position as the company is that we've provided enough training to all of our members of staff, including the one who's been alleged to make these comments here. They've had all the training they need to have and all the training that is necessary in accordance with the Equality Act. And if they then go and make these comments themselves, we're not liable for it because we've done everything we can to stop them from making these comments, and we've taught them about discrimination. That is a defence to a claim for discrimination, where you're essentially dropping your other employee in it because it's their fault and not ours. We're not accepting liability for it. But the tribunal here said that they couldn't argue that it wasn't vicariously liable. The defence wouldn't work because the colleague was sexually harassed and it failed to take any appropriate action when alerted to the harassment by the victim's detailed grievance. Again, this is a situation where they could have handled the matter a lot better by dealing with the grievance properly once Mr. Smith had raised it. If they dealt with it in accordance with their processes and they investigated properly and came to a thorough outcome, they could have avoided a claim that they hadn't dealt with it properly. Or if there was still a claim and they dealt with the grievance as they should have done, they'd be able to rely on the statutory defence. It would be a lot stronger and they could have potentially avoided compensation being awarded against them. Again, another example why people need to be following grievance procedures. Claims arising from a failure to deal with a grievance properly. Alongside discrimination claims, many grievances will be about bullying, not necessarily leading to a discrimination claim, but leading to potential arguments that there's been a breach of trust and confidence, because often bullying allegations will be against line managers or more senior managers, and employees don't really know where to turn when that's the case, because if they raise concerns about their line manager to their line manager, it's not going to get anywhere, so they have to go above their line manager's head, raise to HR. It gets a bit tricky when the investigation starts and the line manager has to carry on working with the employee. So the employee may find here that there's been a breach of trust and confidence, it's untenable to carry on working in this situation, and they resign and they claim constructive dismissal. If we don't deal with grievances properly, then that's likely to be the way that an employee goes. If we don't deal with it properly and say that the grievance is rejected, they appeal and we simply say it's rejected without giving any reasons for it, their next step is to go to a tribunal. And they're likely to do that if we don't deal with the grievance properly in the first place. Now, failure to follow with dealing with a grievance properly isn't always going to be a repudiatory breach of contract, which means they can resign and claim constructive dismissal. It won't always be, but it can be more often than not, in my experience in dealing with these things. A tribunal might find that the poor handling of a grievance and failing to give an explanation for the outcome and the reasons for it didn't constitute a repudiatory breach, and it was right to dismiss the employee's claim. In this particular situation with Sawar, but I feel like that's not a very common approach. I think more often than not, if a grievance process has been dealt with poorly, and then an employee has been has decided to resign and claim constructive dismissal, it's more likely that it's going to be successful, unless an employee can provide otherwise as part of the claim. And if they can give evidence that it was nothing to do with the grievance, or that the process was followed fairly in the first place, then why didn't they deal with the grievance properly and avoid a claim? Claims can be avoided, essentially, if we do follow grievance processes properly, as we should do from the start. That's why the policy is there in the first place. And finally, an employee can't cure its repudiatory breach of contract by its conduct after the event. So once a breach of contract has happened, an employee can take that breach, run with it, and bring a claim in the employment tribunal. They might attempt afterwards to repair the breach of contract and the breach of trust with the employee by dealing with it as a grievance and through its grievance procedure. But if the employee decides to go down the route of bringing a claim, there's not much they can do about it. They can't fix something after the event. So I think if something like a grievance should be raised, yes, deal with it properly. But if it's been dealt with and we go through the grievance process, deal with the grievance after a breach has already happened, we can't necessarily fix it by just dealing with it through the grievance process.
So handling
grievances during disciplinary procedure. Sorry, Emma, go on.
It's all right. So I did mention this before when we're looking at potential headaches as part of grievances, and essentially there's two ways of handling a grievance when a disciplinary procedure is ongoing. The first is to suspend the disciplinary procedure whilst we deal with the grievance, and the secondly is to deal with both issues concurrently. There isn't necessarily a right or wrong way of dealing it. It's more common that you would deal with the issues concurrently if the grievance is related to the disciplinary. We don't want to unnecessarily hold up a disciplinary process if we don't have to. And we do need to be mindful that it could be a bit of a tax from the employee as a way to try and prolong the disciplinary procedures as long as possible, especially when the disciplinary procedure's outcome could potentially lead to something like a gross misconduct dismissal. But it is really important that we don't ignore a grievance, and that's the most important message. And I think this is coming through all of this section here, is that when you are faced with somebody raising a concern, doesn't matter how small it is, that we don't simply ignore it, that we do address it. But if it is related to a disciplinary, then I would simply probably address both matters at the same time. I would have independent people dealing with the issues. What I would ensure that you are doing, though, is delivering the outcome of the grievance ahead of the disciplinary. So it shows that you've considered the concerns that were raised before coming to a conclusion of the disciplinary, especially where it is actually connected. So dealing with unfounded grievances. So where a grievance isn't got any legs, or there's no way of finding the outcome, then potentially disciplinary could be an outcome for that individual, especially if they've acted dishonestly. There's also been a breakdown in trust and confidence, but it has to be demonstrated that the employee has simply not made a mistake. So we do need to be able to demonstrate that it was essentially done maliciously, more than just a genuine "I've misunderstood a situation." So dealing with malicious and or tactical grievances, so where a grievance is malicious, the investigation guide from ACAS, it does suggest that essentially they should be given the benefit of doubt in the first instance, and therefore we should be making it clear where we do believe a grievance was made maliciously. After that, we would potentially recommend that a formal or informal action is taken with that individual, but we do need to be clear and have clear evidence in terms of why we believe it was malicious. In doing that, it may well be that an employee has just received a low-level appraisal, for example, and therefore decides to raise an unfounded grievance against their line manager of bullying, especially because it might be because it's resulted in them not receiving a pay uplift as a result of that. So in the circumstances like that, we need to investigate the motive behind the complaint and where that's come from, and really try and get to the bottom of what the concerns are and what evidence there is to go with the concerns that are being raised. Tactical, so it's best practice to follow the grievance procedure in parallel with other discussions to protect the employee's position, should the negotiations break down and a tribunal claim follow. So essentially that's in relation to disciplinary. If they're trying to do it to defer a disciplinary outcome, then we just do it concurrently with that process so that we can ensure that we're not holding up unnecessarily, but we are still addressing the concerns nevertheless. Okay, and grievance related to stress-related absences. So we've mentioned constructive dismissal, we've mentioned that bullying, harassment. What quite happens when someone raises a grievance is that they feel overwhelmed by the whole situation, and quite often, especially when it's in relation to potential relationships such as a manager relationship, they may go off with a stress-related illness. So when that does happen, we would follow the standard way of managing absence in terms of having welfare checkups with them. We want to try and get them in straight away when they've gone off. And if you have an employee assistance program, there are some employee assistance programs that are really clever and have access to occupational health, where they can do a stress assessment with that individual within the first 7 days. And ideally, that's when you want to capture this individual within the first 7 days of absence to really get to the bottom of what's causing the stress and to try and put a plan in place to try and help them back into the workplace. Ultimately, if it is in relation to the grievance, sometimes I've had this where they've gone off with stress and then they shut down and they won't engage with you. And I think it's really important that we do try and get the message across to them. Look, it's your grievance, you've gone off with stress. The quicker we can deal with this, then the quicker we can obviously get you back into work and hopefully feeling more like themselves. But one thing we do need to consider is whether or not reasonable adjustments need to be put in place. So if they are feeling overwhelmed, so maybe the grievance is related to their working environment, could we put some temporary adjustments in place to assist with that? The other thing we do need to be careful with is disability discrimination. So typically speaking, stress in its own right, in most circumstances wouldn't be seen as a disability, because quite often it's related to like a reaction to an event that's occurred. However, there are occasions where stress actually builds into a bigger illness, and certainly if it goes over a 12-month period and it's having a detrimental impact on their ability to perform day-to-day duties, then it's very likely to be considered as a disability, and therefore we do need to take that into consideration. And finally, constructive dismissal. Of course, we've mentioned this earlier around the risks of constructive dismissal when it comes to grievances, and certainly ones that are not addressed, where the individual has gone off with stress. This is where it's quite a critical time, because if we can't get them to engage with the process and to trust us to be able to investigate their grievance accordingly, the likelihood is that they'll resign and then claim constructive dismissal along with that. What's really, really important, and it is with every process that you deal with when it comes to HR, is keeping a paper trail. So taking notes of every occasion that you've tried to make contact with the individual, every effort that you've made to try and get support for that individual. So whether it's inviting them to welfare meetings, whether it's asking for consent for occupational health or a DP report, all of those things will help in the terms of when they go to a tribunal and put that claim in. Because ultimately the obligation is, well, the onus is on the individual to claim that they've been, to prove that they've been constructively dismissed from the business. So we just need to be able to defend our actions and what we've done to try and mitigate why this person has ended up in this situation.
So to finish off this morning then, we're going to have a look at whistleblowing and the relationship between whistleblowing and raising grievances. They will usually be raised kind of at the same time or in the same way as grievances, and they will normally come in writing or verbally from employees who aren't happy with something specific. The thing is with whistleblowing complaints, this is one of the things that we need to be concerned about, particularly because if we're looking at dismissing somebody who has less than 2 years service and they raise a concern about whistleblowing and then we dismiss them, then the dismissal, if it's because of that whistleblowing complaint, could lead to an unfair dismissal claim and would automatically be an unfair dismissal. So if they raise these concerns, we need to be wary of them, which is why we need to be able to identify them, particularly where they're being thrown in alongside other allegations as part of a grievance about other things like bullying and harassment. So we'll have a look in a second about qualifying disclosures and what they are. Whistleblowing complaints are essentially protected disclosures that are made by employees that have special protection under the whistleblowing legislation. So we'll have a look at those in the next slide. You might have an internal or an external disclosure procedure. Most companies will have a whistleblowing process or a way to deal with these internally, whereby they have a way to contact either HR or a director or their line manager anonymously, where they can make these complaints. It's recommended by a lot of ethical trading companies that there is some kind of process for them to raise these anonymously. Although when employees raise concerns like this anonymously, it's difficult for them to deal with. So employers prefer them really to give their details and explain who they are. If they don't give their name, how are we supposed to speak to them about it and get more information about it and investigate it properly? Yes, we can take what they've said and run with that, but if they haven't told us an awful lot of information or been very specific, how are we supposed to investigate it? So it can hinder the process by not giving the name of the person who's made the complaint. Equally, if this gets to an employment tribunal in some way, it's likely that their name will probably come out of the woodwork at some point as part of the tribunal process, because the tribunal will want to know who's provided this information, and they'll probably need to be attending the court as a witness for one reason or another. So anonymous reporting, while useful, is also unuseful in some circumstances. I'll also have a chat about the impact of any dismissal. So first we'll look at the qualifying disclosures. Qualifying disclosures are disclosures of information where the worker reasonably believes, and it's in the public interest, that one or more of these matters listed below is happening or is likely to happen. So if they're complaining about a criminal offence, a breach of a legal obligation, a miscarriage of justice, danger to health and safety from an individual, damage to the environment, or a deliberate attempt to conceal any of those 5 listed there, are qualifying disclosures capable of being protected. When I say protected, employees who make these complaints about criminal offences or breach of legal obligations are protected from being subject to any less favourable treatment because of that complaint that they've made. So if we decide that this is a complaint that they've made and we decide that we're going to dismiss them because they've made this complaint, that's an automatically unfair dismissal. It's as simple as that. There's no way around it, and there's no way of justifying it either. Similarly, with when grievances are raised and then we decide to discipline somebody for their conduct or their performance, if we were to decide to do that immediately after a grievance happened, it looks like we've done it because the grievance is being raised. Same here. If we were to dismiss somebody after they make a complaint that is a qualifying disclosure capable of this protection, then it looks like we've dismissed them because of that rather than for any other reason, and it's going to be hard to convince the tribunal otherwise. So look out for these things when people are raising grievances. If they make a complaint about breaching a criminal offence or a breach of legal obligation, then be wary. More often than not, you'll see the health and safety disclosure being made more than anything else. So look out for health and safety complaints that are being raised by staff in their grievances. And if they are making complaints about those, treat them like whistleblowing complaints and properly investigate them and go back with a thorough response rather than deciding to do something immediately that you might regret later on. So whistleblowing and risks, we've mentioned this just earlier, but they're not always explicitly labelled as whistleblowing complaints or protected disclosures. In the same way that grievances aren't raised as grievances more often than not, you'll get whistleblowing complaints thrown into grievances where they usually, as I mentioned before about health and safety, they just complain about something that seems to be a health and safety complaint. And however small that is, if it's in the public interest for this complaint to be made, then it would be a protected disclosure. So we couldn't treat them unfairly because they've made that complaint. So just bear that in mind. Disclosures made in bad faith are a problem. The legislation was changed recently, and the legislation used to be that if they've made a disclosure and it was made in good faith, then it would be protected. There was nothing about it being in the public interest a few years ago. And if people made the disclosure, provided it was in good faith, it could have been anything. It could have just been about them and their contract being breached in some way. But when the law was changed, the requirement to make it in good faith was removed and it was replaced with in the public interest. So now a disclosure has to be in the public interest for it to be protected, which applies to fewer things because you can't just be saying something specific that's affecting you. It has to affect the public as a whole. So it's more difficult to get these complaints protected as qualifying and protected disclosures. But disclosures that are still made in bad faith now are still an issue that we need to deal with. And if we find that a disclosure has been made in bad faith, they don't actually believe that it's happened, but they're making it maliciously, and we have enough evidence to support that allegation that it's in bad faith, then we can discipline them for it, and we can dismiss them for it if we decide to do that. And it wouldn't be an automatically unfair dismissal because disclosures made in bad faith are not protected because the employee did not believe that this was actually a complaint that needed to be made. So that might come out of the investigation, and if it does come out of the investigation that it's not a real complaint or that it is made in bad faith, then we can deal with it as a misconduct issue, which could lead to warnings or dismissal. Dismissal or detriment, if we are going to be dismissing somebody, an employee does still face a bit of an uphill battle because what they need to do is convince the tribunal that there was a connection to them making a disclosure, and that's the reason why they were dismissed. If we have evidence to suggest that this conduct or performance is the reason for their dismissal, then yes, we need to show that we've followed a process in relation to those, like the disciplinary process or the performance management process, or if they've been there for less than 2 years, where we don't necessarily have to do that full disciplinary process route, we need to be able to have some evidence to suggest that the dismissal was for some other reason, or that the detriment was for some other reason, rather than this disclosure that had been made. The employee needs to show that there was a link there, and if there is no link, then there is no claim. It's as simple as that. And tribunals are looking out for these and do tend to fall on the side of employees, really, when they've made disclosures and there is enough information there for them to have made it. If they've made it in good faith and it's in the public interest, tribunals a lot of the time will support employees in these types of claims. So we need to make sure that we're following all the processes that we can from early stage, and we do deal with the investigations properly before it gets as far as an employment tribunal claim being brought.
Okay, so just to summarise then on what we've discussed this morning, we really do hope that you have found this morning useful, and don't forget, please ask any questions at the end. So obviously, following the grievance procedure, I think we've identified that is extremely important, and not to stray away from that. And even if it looks a little bit protracted, if you don't follow your own procedure, then it is likely to mean an uplift in compensation at a tribunal. For those businesses that may be in their infancy, or very, very small, that don't have an employee handbook, then it's important to follow the ACAS code of guidance. And if you visit the ACAS website, all the guidance documents for all the relevant procedures that tribunals will review are listed there. And as I mentioned earlier, try to resolve the issues informally and proactively where possible. It's always to address it when it's still at a very small matter stage, rather than it being a huge issue where we've got a number of individuals, for example, not talking to one another. If we can just nip things in the bud, then that would be great. Very, very important, and this goes for anything that you're dealing with when it comes to individuals, is to keep written records. It is amazing how many times we get to a tribunal and we find that there's no written record of conversations, etc., which make it difficult for them to then be relied on. And then give full reasons of decisions. Your outcome letter needs to be really, really clear. So think about the complaint in itself, try and break it down, bullet point it, and then address each concern as you come to it. So matter number one, address it, provide evidence. Why have you come to that conclusion? Link it to people you've spoken to, link it to documents that you've reviewed. Be really, really clear in terms of your thought process, because that will help the employee understand why you've reached that decision. It will help the appeal officer understand as well why you've come to that decision. What it will also do, certainly in a case where somebody's trying to go to a tribunal, it gives their legal representative the opportunity to really understand what's happened here in the thought process from the business. And the clearer you make it, the easier it is for them to advise their client on whether or not they've got a good case. Where you've got a very weak letter, there is a much higher chance of that client, of that employee, having a bigger argument, should we say, for tribunal. So that does conclude things for today. Has anybody got any questions?
If there's nothing immediately, we are around. Chances are you all have our contact details, and should you want to get in touch for any reason, then please feel free, whether it's about today's webinar or whether it's about anything else. Feel free to get in touch. Just let us know if we can help with anything, and we'll be happy to do that. But thanks a lot for all coming along today. We will likely send out some feedback questionnaires for you all. Hopefully you'll be able to complete those and send them back into us. That would be very much appreciated. But we're very grateful for your attendance, and hope you've enjoyed it. Thank you very much.